Law for Life, the podcast, with Franklins Solicitors.
Hello and welcome to the first episode of Law for Life, the Franklins podcast. I'm Chris Gregg and it's great to be joined in the studio by George Smith from Franklins. Hello, George.
Hello, Chris. Thanks for having me.
Thank you so much for joining me. Now, you are the head of Litigation and Dispute Resolution at Franklins, and the reason you're here with me today is we're going to be talking all about wills and what happens after you've died. So presuming that you've actually taken the time to write a will, there's a lot more to it than you might imagine, because your job at Franklins is to basically make sure that everything's done fairly and look after people's estates after they've gone, in terms of things like inheritance. And there's a bit of legislation called the Inheritance Act from 1975, which is very important here. So can you give me a little summary of what that involves?
Of course, Chris. So the full title of the Inheritance Act is the Inheritance for Provision and Family Dependants Act 1975. And what this does is it allows disappointed beneficiaries to make a claim for reasonable financial provision if they are not left enough or completely excluded out of a will.
Okay, see, this is something that I wasn't aware of before we started talking about this podcast, because I thought when you make a will, that's it. It's written down in the will. Whatever you write down, I want to give all my money to the Benevolent Radio Presenters Fund. That's what's going to happen. Doesn't matter if I've got children or dependents or a dog or whatever. But actually, that's not the case. The Inheritance Act gives certain protection for people that have been left out of wills.
That's correct. So if, for example, you left everything to the Benevolent Society, the radio presenters,
yes.
If there is one, and your children were financially reliant upon you, or if they were of now adult age, if they're reliant on state benefits, for example, not able to maintain themselves, they can bring a claim against your estate, and the court will consider their needs and finances and the need for reasonable financial provision balanced against any claim that the Radio Presenters Society may make.
Okay, and you know, they're going to want the money because I don't think they get much.
Exactly.
So is it very much dependent on the financial situation of your potential beneficiaries that you've left out?
Yes, so there has to be a need for reasonable financial provision, except for if you are a spouse, the court will consider what is necessary for them to receive. So they have a greater protection under the Act.
Okay, so it does make a difference whether you're married or not?
Yes, it does. Okay,
because I think a lot of people maybe don't get married and they live together, and a lot of the time they don't even get around to making a will, and it makes such a difference, doesn't it?
It does. If you're not married and you're a cohabitee for at least 2 years, then you will have a claim. Quite often that would be a claim for a life interest in the property.
Okay.
So you could stay there for the rest of your life.
Brilliant. Well, that could be really handy if you don't have a huge income and you've been living in your family home for a while. You don't want to suddenly find that you're homeless because
Correct.
Your partner's died suddenly.
That's right. So the law will try and allow you to maintain the same standard of life that you had before.
So do you find that at Franklins people come to you and they're in a really difficult situation because somebody's died unexpectedly, they didn't have all the paperwork there, and it's a bit of a mess, and they're saying, look, can you help me here, because there's a lot of issues, we've all fallen out over the money, nothing was written down, and you have to kind of untangle that mess of like family disputes and soap opera type scenes.
That's right. So we ordinarily start off with a family tree to understand everyone that's involved, what everyone needs, how much money is in the estate, what is available. We can only work with the net estate, so some properties might transfer by way of survivorship. We can unpick that under Section 9 of the Act and bring that back into the estate if it transfers by way of survivorship. But generally, it's the net estate that's available after all inheritance tax and everything is dealt with.
So whatever's left over after
Yes.
all of the taxes have been paid, that's
Correct,
what you're playing with.
Yes.
So what kind of situations can you bring in the Inheritance Act into to kind of help out?
So, for example, if you are a spouse that's been left out of the will or have not been left enough, then the court will take into account what is necessary for you to receive, which is a greater protection than, let's say, a non-married couple living together who the deceased might have left all of their money to their children, leaving the non-married spouse out of the estate or not enough, and they need to keep living in the property and maintain their standards going forward to pay utilities and things like that. There may be situations where for some reason there's more than one child and one is receiving less than another, and as an adult child they're reliant on state benefits or they have a greater need for provision. So we'll look at any lifetime gifts or anything that happened just to make sure that everyone is provided for that needs to be provided for, and the court take that into account.
So it's more about need and your circumstances and whether you've got enough money than saying, oh, it's not fair, my brother got more money than me.
Yeah, so it's not really a moral duty that the deceased owes, but we have to look at what their wishes and intentions were to make sure that it's dealt with as so far as their estate as they would want to, but the claimants receive what they need for their reasonable financial provision.
So would you normally work with the whole family all at the same time, or if there's a dispute, would they need to have a different solicitor if they're kind of acting against each other?
Yeah, so we would want to avoid a conflict of interest. So if it's one disappointed beneficiary, then we'll act for them, or we'll act for the executors of the estate in defending any claims brought by claimants.
Okay, and what's the process? So they come into your office, they sit down, you have to go through all of their expenses and living costs, I guess, and get all of the financials down.
That's right. We take a note of their financial means and what they need for the future, and take a full account of where we are with the estate, the process as to whether a grant has been obtained, and we have to act quickly because there's only 6 months from the date of the grant before we have to issue proceedings. So there's a very short time limit indeed.
That is really important. So people might not realise the clock's ticking, and these things, I guess, take a little while to get all of the evidence together and prepare your case.
Exactly. So it's best to issue before the 6 months ends. You then have 4 months in which to serve your proceedings. So there's time to enter into mediation or other forms of alternative dispute resolution to try and bring a sensible conclusion without going all the way to court. If, for whatever reason, the time limit of 6 months is missed, you can apply to the court under Section 4 of the Act for the court to waive that time limit, so you can still proceed with your case.
Okay, so there is a way through that, but
there
it's
is
extra hassle to get that all agreed.
Yes, you have to show good reason to the court why they should waive that time limit.
Okay, so just saying I didn't even realise. I was just getting on with my life, and people are busy, and 6 months isn't that long, especially when you've got to deal with the death of a loved one, and there's a lot to go through. And
yes.
Sometimes feeling a bit aggrieved about a will might be something that you don't realise until you've realised you can't make ends meet, and suddenly there's not enough money to go around. Yeah.
And executors don't need to put beneficiaries on notice that they've applied for the grant either. So the best way to do that is to check the probate registry website, and you can lodge a standing search as well, which will tell you when a grant is issued, and you'll get a copy of it as well with the will.
Okay, that sounds handy, but it also sounds a little bit complicated. So is that something that you could help with?
Yes, we could, yes.
Okay.
Yeah.
That's reassuring. I think this is why when you're in this kind of situation, you need to get someone professional to help you with this stuff, because it's just that basic advice, the 6 month time limit, how to search the register, all those things that the average person isn't expected to know how to do.
Yes, we can sit through and guide you through it, sit down and discuss all the options and means and the way forward.
Fantastic. So what kind of challenges do claimants face when they're making a claim under the Act? What are some of the things that might throw a spanner in the works?
Well, there's other beneficiaries, of course, that are going to be wanting their entitlement to the will. So they will obviously be receiving less if the claim is to succeed. So the challenge is coming up with a fair solution that's acceptable to everybody. You've got to obviously recognise that costs will increase, and somebody at the end of the case is going to have to pay those costs. So the ordinary rule is the loser pays the winner's costs, but the court can depart from that and make any decision of its own. But if it's found that the estate was wrong to, the deceased was wrong to make the will in the way that they did and exclude the beneficiaries that they did, then normally the ordinary rule is the estate pays those costs of the litigation. But of course, that's going to come out of estate funds. So we have to try and preserve the funds as much as possible to come up with a very sensible solution that benefits everybody.
This is where it gets a little bit unfair, I think, because it might be that the deceased person has donated their money to a charity, and the charity obviously wants that money, but should the charity have to be paying legal costs?
Well, they shouldn't, and obviously, charitable causes are very important because the deceased obviously left their money to charity for a reason. It may be that they were close to their heart or something like that, or it may be a tax-saving decision, for example. So it's very important that charities get their money, but that has to be balanced against disappointed beneficiaries that do need that reasonable financial provision. In fact, there was a very leading case that went to the Supreme Court called Islet and Blue Cross that we weren't involved with, obviously, but it did give the court, the lower courts that are now bound by that decision from 2015, some understanding of how the Inheritance Act works and what factors that they need to apply.
Okay, and what was the upshot of that?
Well, the what that case was that the deceased and her estranged daughter had fell out many years ago, and the deceased actually had quite a lot of money, and the daughter, I think she had run off with her boyfriend who the deceased didn't approve of. There was no attempts to reconcile the relationship over the years, and sadly the mother died, and the daughter brought a claim against the estate for reasonable financial provision. At first instance, the county court awarded her £50,000 to help with her council house. She was reliant on state benefits. At the Court of Appeal, that was increased to £143,000. The charities, they were animal charities, I believe, they decided to appeal that onto the Supreme Court, which took many years, and the Supreme Court reinstated the original decision of the county court, so she got her £50,000. So even though her mother left her nothing and had excluded her from her will, she was able to make a recovery because she had no means and she was reliant on state benefits.
That's so interesting, and I think a lot of people use wills as a way to kind of attack people after they've gone. So they'll write something really nasty in their will just as a way of kind of exerting their vengeance from beyond the grave. If it's unfair, then it's great that there's some protection there to stop that happening.
I understand that there was a deceased person who wrote in their will that they left their son a dictionary so that he could find the words to apologise.
I love that kind of, well, it's very naughty, but it is very funny. And I mean, you must have seen lots of examples of this sort of thing where somebody is, can you put a clause in your will that says, I'm going to leave you £50,000 on the provision that you never speak to that witch again, or something like that?
You could do. Yeah. Yes, you can leave haunted house provisions. You must sleep in a haunted house before you get my money.
Really?
Yes.
And that's all legal? That has to be done?
Absolutely, yeah. You have to do that. So, yes, you can leave provisions to look after your family pets, things like that. So guardian for your children, how you want to be disposed of. So do you want to be cremated or buried? What sort of music do you want at your funeral? Things like that.
And whatever you write, it has to be done if it's not...
Well, the executor has to try and follow your wishes so far as is reasonably possible. Yes.
Okay. So if you're asking for your ashes to be scattered on the surface of Mars, that might not be practical.
No, but they could try their best.
You just stick it on a firework and send it up into the sky.
Save it for future generations that might be able to do that in the future.
Yeah, it's doable. So I think, obviously, the most important thing for everybody is to make sure that you do have a will, because there's so much that can go wrong if you don't. And it's worth mentioning that Franklins do offer a full service of helping you get your will written and make sure that it's watertight. And I guess while the will is being written, they would advise you if you've put something in your will which would contravene the Inheritance Act and wouldn't actually happen in the end.
Yes, we can try and allay that as much as possible so that those sorts of claims are avoided. But also making a will means that the executors don't have to struggle with decisions such as music at the funeral, whether someone wants to be buried or cremated. So those decisions are taken away from the executors. There's going to be less of an argument if you've got more than, say, one executor who doesn't know what to do. So it really helps them.
Mm. And do you think it is important to remember some charities in your will, as long as you've done it proportionately?
Yes, if they're close to your heart. And also it can be a tax-saving provision as well, to leave money to charity. And charities are reliant upon estate assets as well to survive.
Mm. And I think a lot of the time they do have an offer where you can get your will written and then the charity kind of contributes towards that. So
there can be
it
that.
helps.
Yeah. They offer certain periods where they offer deals where they will assist with the writing of the will.
Mm. I'm sure they're very happy to help you with that. Okay, that's so interesting. Is there anything else that we haven't covered that we need to tell people about with this area? Because it does seem like it's a bit of a minefield. There's a lot to kind of come to terms with. And I guess even if you're not sure whether you are entitled to anything, this is where help is useful. And can people come and talk to you without any obligation?
Well, obviously our time is precious, and we're happy to have quick chats and things, but we do offer fixed fee consultations where people can come and lay the will and the grant out before us and just discuss everything, get everything off their chest, and we can make a plan for the way forward. But you should definitely receive professional advice, because this area is very difficult. There are very strict time limits, and you have to be compliant with all the court rules and procedures. So definitely seek professional advice. Yeah.
And if they sit down with you, you could tell them in the meeting, I think this is something that's worth looking at, or no, this is a perfectly good will. Just suck it up. This is how it's going to be.
Yeah, quite often if we can't help further, it's a comfort to them. No, that's just what they want to hear going forwards. That this is the reason why they've been excluded or receive less. So they just need to hear it from somebody else. Yeah. If we can give a good explanation. Yeah,
and it puts your mind at rest. But you'd be able to say to them, look, this is something we could contest.
Yes.
But this is the likely cost of that, and how much time it's going to take, and those kind of factors.
Yes, that's right.
Yeah, absolutely. Okay, well, that was really interesting, George. Thank you very much for coming on and talking to us. And you are the head of Litigation and Dispute Resolution at Franklins, so you'll be the guy that people could be sitting down and talking to, and hopefully seeing a friendly face can put people's minds at rest that there's somebody there that's going to be fighting your corner and friendly and helpful, and put it all in plain English for them.
That's right. And thank you so much for having me, Chris. It's been a pleasure.
No worries. And if you would like to get in touch, all the details are on the podcast, and you can contact Franklins to get them to help with your situation. Thanks a lot, George.
Thanks, Chris.